Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. This is also professional ethics class. Friends, already we have completed the right to practice of advocates as envisaged in section 29 and 30. Right now we are going to deal with section 33. Section 33 also says the right to practice by the advocates. Why all these sections? Every section is different. That's why even though you are called as advocate, mukhtar, barrister, vakil, lawyer, pleader, revenue agent in different names, but still every name has got its own meaning. Even though you think that they are synonymous names, every word has got its own meaning. Likewise, section 29 says broad classification. So advocates are only the class of persons legally entitled to practice. Section 30, it gives specific right of the advocates to enter the Supreme Court and practice. Right of the advocates to enter the High Court and practice. Right of the advocates to enter before any authority, before any tribunal and practice. Now we are coming to section 33. Advocates alone are entitled to practice. Advocates are alone, no others. So this is more important. So because a private person cannot barge in the court and claim to argue because he knows the entire thing. Because section 32 says that the court can allow any person other than advocate to appear in a particular case. Appearance is different from practicing. Appearance is different from arguing. You have to know the difference. Right. So section 33 says advocates are alone entitled to practice. So I will give you a couple of case laws. One is Rastogi versus Giridhari Sarma 1978. Definitely it is the celebrated case. Don't forget to mention it whenever section 33 comes. Rastogi versus Giridhari Sarma 1978. In this case, Supreme Court held that a private person, of course not an advocate, private person means who is not an advocate, a private person has no right, the private person has no right to barge into the court and claim to argue for a party. Why? Here the clash comes because Article 19 1G, what does it say? It gives the right, it gives the freedom, fundamental freedom to practice any profession or trade. So therefore, so many people are under the impression that once he studied law, he can come to the court and he can argue. No, you have to become an advocate. You have to write the All India Bar examination. You have to get central. So such persons who are only advocates are only entitled to practice, not all the lawyers. This is the difference in section 33. Right? If a non-advocate specializes in court practice, even then he can't be allowed. Non-advocate cannot be allowed. In this reference, please refer to my video number 2143. Video number 2143, where an advocate, so he is not where a chartered accountant, he tried to pose as though he is an advocate and he was arguing before Rajahmundry court for so many years. Incidentally, he was caught, he was booked under 420 IPC as well as section 45 of the Advocates Act. So I think in one of my two videos earlier, I mentioned this case also. And coming to the second case law, Sampath Kumar versus Bar Council of India 1994. Sampath Kumar versus Bar Council of India 1994. So please remember, Supreme Court observed that right to practice as an advocate, is a statutory right and it's not a fundamental right. Please remember, sometimes Supreme Court stated that it is a fundamental right in some other case, right? So please remember, validity of rule number 9 in chapter 3 part 6 is ultra vires. Of course, here right to practice is an advocate is a statutory. Why? Because you are guided or you are controlled or your interests are protected under the Advocates Act 1961. The Bar Council of India is there to protect your right, to protect your privileges, to protect your interest, and also at the same time, if you exhibit any misconduct, yes, definitely they can take departmental or disciplinary action against you. Right? So, such is the case of an advocate. Therefore, an advocate is only entitled to, advocate alone is entitled to practice in the court of law. Okay? Then we'll discuss some section 32 separately because already 5 minutes over. Right? With this, I am concluding. Thank you very much.